Welcome everybody. Thanks for coming and breaking up your lunch conversations. My name is Frederik Zuiderveen-Borgesius of Radboud University, and today I'm mostly here with my hat on of one of the people involved in the Europe-wide consortium FINDHR, or FINDHR, and that is a consortium of 13 partners, some universities, some NGOs, some companies, and we're all engaged in trying to help to develop algorithmic systems for in HR situations, in recruitment, but then in a fair and non-discriminatory way. Because imagine there is, in many situations, companies can get thousands of job applications for one job. Then perhaps human HR people take a serious look at the first 50 or 60, but then if you have 5 good candidates, then you can invite them for an interview, and that is somewhat unfair towards the other 950 letters that never get looked at. So loads of state organizations and companies use automated systems to make a first selection, and there's actually a good pro-fairness argument for automating part of the system, because then at least all, in our example, 1,000 applications get at least a chance of being invited for an interview, etc. But many systems are have problems. For instance, there's many systems that basically don't work at all. They're basically rolling a dice. And there's many systems that do make a selection, but that end up discriminating unfairly. For instance, a famous example now, a couple of years ago, was Amazon. In this case, they didn't use it in the wild, so they deserve compliments for that. But Amazon was also in that situation. Loads of applications. And they built an AI system to make a first selection. They trained it upon their, like many AI systems, the system was trained upon earlier decisions by humans, like AI system, this is how you should behave. But like many big tech companies, there's a gender imbalance at Amazon. And even if the developers told the AI system, ignore gender, the AI system kept on selecting mostly men. And in the end, Amazon, and they have deep pockets to throw more money and development time and more computer science PhDs at it, at the end had to give up. You know what, we cannot repair it because our training data are so biased again towards men because of our old biased hiring decisions that they couldn't repair it and gave up. So that sketches the topic for today. And we have a varied panel, different disciplines, different backgrounds. And I'll introduce each of them, and then we are not going to do long presentations or PowerPoints, so we're improvising a bit. That may be chaotic, then at least we hope it is entertaining chaos. And at some point we will also ask you whether you have questions. But first I'll introduce the speakers to you in this order. Next to me is Dr. Angela Müller. She's the Executive Director of Algorithm Watch in Switzerland. And Algorithm Watch is an important NGO focusing on basically the use of algorithms in society and possible problems for human rights and fairness. And at Algorithm Watch, she heads the policy and advocacy team. She has much more varied background than me because I'm a lawyer, but she studied political philosophy and ethics and then added a PhD in law. And earlier this year, she was named one of the 100 brilliant women in AI ethics. So, honored to have Angela here. Then, let me see whether I get the pronunciation right. Roger André Seureux. An associate professor in STS, Science and Technology Studies at the Norwegian University of Science and Technology. He studied in Japan for a year as well. I'm quite jealous of that. And he is deeply involved in the Bias project, and that is a kind of sister project of the FINDHR project that I work in, also funded by the same European Union funding scheme. And their project, with a slightly different focus, also focuses on AI and fairness in recruitment. Welcome, Roger. Then Dr. Asha Viega, PhD in computer science, and she's a tenure-track faculty member at the Max Planck Institute for Security and Privacy in Bochum, and working on many topics, but including privacy and non-discrimination and fairness in the context of algorithmic systems, etc., and also involved in the FINDHR project. So NGO, academic, and then at the far end, Ms. Mila Vidina, who works at Equinet, and that is the European network of equality bodies. You could also say the network of non-discrimination authorities. And there she is the senior policy officer and leading Equinet's work on AI and algorithmic discrimination. And she studied politics, I think, in Princeton, among other places. Okay, political philosophy. So a very panel. Then I'm going to start off. And my first question is, and we'll do it in the same order, is what do you see as the main risk if an organization uses AI or an algorithmic system in recruitment?
Okay, then I'm going to start off the panel. I think maybe 3 dimensions of risks. The first one being that you just said, you know, there's a case for using automated system, but I think that's based on the presumption that these tools are neutral and objective, and that's just not the case. They're not, and of course that can lead to discriminatory effects. That can also lead to just losing qualified people that you might consider in other respects. A second dimension, I would say, is what you also a bit referred to in your opening remarks, that there's just a lot of snake oil, especially in this area outside. So a lot of systems that are just sold with a huge marketing machine behind, but that don't actually work, or that are not based on like scientifically valid, on a scientifically valid basis. And I think, you know, so it could be that all of this happens for no reasons, or at least not in a scientifically valid way. And I think that's one of the major issues also in this field. And then the third is, or like, you know, it contributes to increasing the power asymmetry that is already characterizing that space. Of course, there's like the power asymmetry between employer and employees, but then applicants are not even employees, right? So the power asymmetry and also the knowledge asymmetry, all of that is even greater. And, you know, applicants are just find themselves vis-a-vis a black box. They're exposed to the use of that systems, and they don't really know about it. And they're also quite powerless about it. I mean, they don't even have like employees' rights. And I think that's a particularly important dimension also, like this power asymmetry aspect of it. Because often you hear like this comparison, you know, the judge or the recruiter, like the human recruiter is also biased. So, you know, the output might not be better, but I think that misses a point of the process is also important. For me as a human, it is important to be vis-a-vis a person and to try to convince this person, be it in the courtroom or be it in like a recruiting situation. And it's not just the output that is decisive, but really also the process that, that there is something different when it is a human recruiter, I mean, in a typical interview situation, for example.
Yeah, thank you. Roger, any first thoughts about the main risks that you see?
Yes, thank you very much. I can build a bit on what Angela said here, and I think we agree a lot. So in the bias project that I'm leading, we're looking at how we can mitigate biases of AI in the labor market. And we see that one of the biggest risks is the lack of knowledge of what AI is and what it can do, and also what it cannot do. So we are really trying to empower the HR community to learn more about AI if they are going to use it. Just some commercial for our project. In your bag, you can actually find a little flyer from our project if you want to learn more about it. To build on what you said about the risks, what we see when we have done a lot of capacity building with especially HR people is that AI is often treated like quite a black box. So with risks in what data comes into the black box, with risks of how is it being processed, and also maybe most importantly from the human side, how do we interpret the data that comes out? Do we see it as the grand truth, or is it something that can be discussed? So we also think that having a human in the loop is quite important. But right now, we see that many companies are in quite an experimental phase of how to use AI in recruitment and also management.
Thank you very much, Asha. First thoughts?
Yes, I'm a computer scientist, so perhaps because I have seen how these systems work from the inside and how they are built, my biggest concern is that we convert everything in the hiring process into numbers. Everything, so the process that has inherently human aspects has to be converted into something that is computational. And that means people have to be represented in a way that is digestible by a machine. Our goals have to be phrased as an optimization objective for an algorithm. And so this process, the measurement process, in a sense, determines what are the good outcomes, what are the bad outcomes, who are the good candidates, who are the bad candidates. And there are a number of different risks that we can foresee with this sort of computational transformation. One that perhaps merits mentioning is the uniformity that we introduce and the reduction of individuality. So for instance, we might overlook people with non-standard backgrounds because they just don't fit the typical patterns that the machine might learn from the data. We might overlook people whose demographic groups, so the demographic groups they come from, we just don't have any data on them. So then the machine doesn't know how to make the right decisions. And then people who present in very original ways, right? When we introduce standardization, inevitably what this leads to is we have some sort of narrowing of what we consider good, and so we're going to lose out on some originality that is there at the margin. So these are some of the risks I can see in this process.
Thank you very much. And Mila, any first thoughts? And perhaps you could also briefly say something about what Equinet is doing in this field.
Well, let me first preface by saying that I disagree with preceding comments fundamentally. No, this is not the case. I'm mindful of the fact of not preaching to the choir and not repeating what you said. So it will be difficult to build upon this comprehensive analysis. So we are a network. Equinet is a network of public equality defenders, or equality watchdogs, if you will. So it's 47 institutions from all across Europe that provide assistance to victims of discrimination. And victims is the language, unfortunately, of the directives, but assistance to those affected, free of charge, with lower thresholds, less administrative burden than courts, is at the heart of what equality bodies do, and it's specifically anchored in the EU directives, by virtue of which equality bodies are created. But beyond that, they do a lot of prevention and promotion. For example, training for recruiters, creating AI and discrimination-free charters, or also handling cases. There is now a case against Meta that has been brought to 3 equality institutions. It's in France and Netherlands and the UK for gender discriminatory job targeting advertisements. So in a nutshell, that's what we do. So from that perspective, which is a perspective of institutional perspective from independent bodies, I would also like to emphasize, I guess, the institutional or structural dimensions of labor discrimination, and specifically recruitment discrimination. You already mentioned the need to quantify and to give expression to discrimination in numbers, but not everything can be quantified. There are invisible barriers, and for example, historical structural bias cannot be disentangled or eradicated. It's built into the data, the model, because it's based on the real-world practices, and those model approximates the practices. And then we have the metrics of workplace success, such as a performance review or a salary, which do not necessarily reflect competence. Instead, they could be a result from a workplace bias, one that has been institutionalized and has been embedded structurally within our society, not only within organizations. And a third challenge, which I think might be specific to the recruitment sector, is the challenge of the complexity of the interaction between human bias and technological bias. Arguably, recruitment is a sphere of employment in which the specificity of recruitment is that there is still a prominent human element. A study by the Dutch Institute has found that most employers using algorithmic systems, they do not use them for selecting or even screening candidates. They do it to look for candidates and to disseminate their advertisements on big social platforms. So in the different phases of recruitment, sourcing, screening, up until evaluation, technology interacts with the human oversight, and I think it would be more challenging to prevent discrimination if you have to examine in parallel those interacting sources of bias. Yeah, thank you.
Thank you. How do you come to 47 members? Is it broader than the EU, or do certain...
I should have specified. So equality bodies are set by virtue of EU directive, so around 2000. But in some countries, they precede the EU legislation, and there are countries outside of the European Union who also have equality authorities. Some countries have several. So when you hear the number 47, you think of the broader European neighborhood, and you also think that in some states you have more than one equality body. For example, gender equality could be separate from race and ethnicity, could be separate from disability, because of historical traditions also and the way. Yeah.
Thank you very much. Then I was wondering whether, and we'll do the same order, whether you have, I'm going to ask two questions and you can react to the one that you feel most comfortable with. Whether you have any advice to, let's say, a company that, and typically I think the company will not develop the AI system itself. Most companies are not as rich as Amazon. They will typically license a system that an AI vendor or developer offers as a cloud solution or whatever. Whether you have any advice to a company that licenses or uses such a tool. And I was also wondering, Angela already confirmed that you also see the fairness argument, at least the argument for using such systems sometimes. But from the others, I would like to hear, because I asked you for risks and you mentioned therefore risks, but I was wondering whether you're generally against or that you see also the points in favor of automating the process. Angela, any thoughts?
Yeah, maybe what can companies do? I think, they should start with fighting discrimination in recruiting in general first, whether it's automated or not. And then consider, what challenge do we actually have? I mean, do we have a challenge with recruiting, or is it just something, that takes a lot of our time? But that's a bit the nature of the thing. And then, what solutions do we need? Perhaps there are also no-tech or low-tech solutions to tackle the challenges they have. And, also avoid falling for what I just called before snake oil, because just because something is on the market, it doesn't mean it works and it will solve your problems. And if they decide to use tools, then I think they have to be very clear in saying we do not experiment with that stuff. I mean, we've heard before a lot of people experiment with it, but actually this is something I feel you should just test and evaluate really before you deploy it and while you deploy it. Because, discrimination is not something that you can say, oh, sorry, that was the effect of our experimenting with a tool. So that to really audit things, to really assess what impact these systems can have, that also requires a lot of information from the provider side. And there we have a next problem because there is a power asymmetry often to the provider. But yeah, that's then also the responsibility of the deployer to say, we need that information, and as long as we do not have that information, the question is whether we should really use the tool. And then, also if you deploy it, be aware of it's not only about tech and it's not only about having the perfect system at a technical level, but it's really how you use it, what processes around it, how you train people, how you're transparent about it, and so on. Because the roots of discrimination and biases and so on are do not just lie at the technical level. And I think that's very important also to acknowledge for companies, for example.
Thank you very much, Roger.
Yes, I think as a social scientist, it's very important for companies to be aware of their social values and also realizing that technology is never neutral, but is developed by someone for some purpose, and especially with AI that builds on so much historic data. For companies to be more aware of what are their company values. So if you are hiring for a position, you need to take into consideration not only can the person do that exact job, but also how is your company composed? Is it, for example, a company of only men? Is it a company that discriminates, for example, by age? And that can be individual for each company, but also each company is also part of a larger societal network. So, and this is something we have discussed quite a lot with the HR. So when we have case studies on large universities, for example, it can differ on group composition down on the research group level, on the department level, faculty level, and on a huge university level where you might have 50,000 employees. So where should you take measures, and how should an AI system understand where it should potentially intervene with recommendations of here you should have, for example, more diversity than you have already. But that is quite tricky because what we see when we especially engage with HR is that they have a lot of human knowledge or some gut feeling that they can't really describe in a way in the recruitment process, and that computer systems can't necessarily pick up on very easily. And of course it should be fair and lawful, but there are some parts of the human recruitment process that is really difficult to try to quantify if that is the goal. So I would say being more aware of what are your actual company values and what you want with this, not only experimenting for the fun of experimenting.
Thank you very much. Or it could be experimenting because the management thinks firing HR people and just hiring an AI system may be cheaper, perhaps. Asha, thoughts?
Indeed. So any company that wants to use AI tools in hiring should have awareness of where discrimination might arise in the entire pipeline of the system that they are using. And I have to say that academic literature is partially at fault for this current state of things. People mostly focus on the algorithms, and they investigate whether the algorithmic decision-making within the system can exhibit discriminatory behaviors, but typically these algorithms are embedded within larger systems, so we have to pay attention to the data, we have to pay attention to the interfaces that are used to present the results of the algorithms, we have to pay attention to user interactions or recruiter interactions with the system, and how, for example, different interface elements might impact how people make those final decisions. So the awareness of the entire pipeline and where discrimination might arise within all of those components, and how that translates to the final outcome, which I guess from the non-discrimination law perspective is what matters most, how we can propagate that back throughout this pipeline. And just briefly maybe to comment on that question of whether there are only risks or whether there is any hope for these systems. I think there is. As you mentioned before, we have to pay attention to not only technical biases, but also human biases. And if we have a process that doesn't use any technologies, only based on human decisions, of course, that is also prone to human biases. So is there a way for us to use technology and use AI hiring tools to fix that bias that would be there in a human hiring process? I think that would be a productive way to move forward, but for this we would have to go beyond that binary of use and non-use and find some hybrid ways for using the technology together with the human processes.
Thank you very much. Asha, Mila, more thoughts on this?
Okay, and then again, from the perspective of equality defenders, independent, I think, first of all, I don't think that all employers are aware that algorithmic systems entail the risk of discrimination, surprisingly enough. We had the Swedish Equality Input, for example, worked at the government and did a comprehensive study, and it turned out that employers don't know. Some of them don't even know that they're employing algorithmic systems for recruitment, and they don't do fairness checks. And the findings were confirmed also by the Dutch Institute for Human Rights, who for several years actually chose recruitment as a priority for their work on digitalization of human rights. So there is abundant evidence also coming from public enforcement that there is no awareness and also no knowledge that non-discrimination law applies also to algorithmic discrimination, and it has very tangible and concrete consequences for employers, because they're the ones liable under the non-discrimination law, and not the developers. And the potential responsibility for algorithmic developers does not detract from the employer's responsibility. They have extra intensive to be cautious because the way non-discrimination law operates, which is wonderful. In other words, as an employer, you could be held liable for discrimination even if you do it unintentionally. Even if you have an unconscious bias or stereotype, there is case law that says that it could be even direct discrimination. And so even if they have no knowledge of it, they would still be held accountable. So what they better do is they should do their equality due diligence. So this means equality risk assessment and impact assessment, and try to undertake preventive measures. So they test and assess, evaluate comprehensively and periodically, and also incentivize and talk to developers who are designing the tools for them, so that the tool is designed in such a way that it could produce evidence that the system is doing what it's supposed to do. So those are some, also creating a legal duty to prevent discrimination, so an active obligation to prevent. So when this is called inequality duty, it exists across Europe in some legislations. And we as organizations have been promoting it because we think that equality mainstreaming, basically creating an active obligation to inspect, to check iteratively through the recruitment process, that every stage does not contribute to discrimination, is really the way to go with algorithms, because of how interconnected and throughout the pipeline and processes those technologies work. And one last bit, and a reason for hope, there was a new legislation, this was passed just 2 weeks ago or 1 week ago, on basically giving more powers, independence to equality bodies, and some of those powers are directly linked or could be applicable, specifically in context of algorithmic discriminations. For example, there is a reference to intersectional discrimination and creating incentivizing states to create conditions so that equality bodies could also take intersectional discrimination in account whenever they do preventive actions, such as equality mainstreaming, positive action, etc. So now that we have the law, even though it's not the equality directives per se, it is in a legislation that spells out powers for the bodies under the equality directives that do the monitoring and enforcement. It could be used as a legal instrument also in the context of for employment. Thank you.
Thank you very much. Could you perhaps, this is traditionally more of a privacy conference, could you perhaps explain what intersectionality means?
Okay, it's a buzzword, it's a very trendy word. You probably heard it a lot. But a simplified way to explain it is to go back to what was mentioned about power imbalance and dynamics. So under non-discrimination law, under EU law, there are six, right, not five, protected characteristics. And they, so EU law is enforced with respect to that. And then under national law, most countries have gone beyond that. So even you have things such as socioeconomic status somewhere protected. And you also have multiple discrimination. So the law protects you if some of those characteristics act in an additive or cumulative fashion. Huh? So for example, you have age and gender, a typical one. Or you have race and religion, another one. But then there is a third concept, which is still not, that legally it was only introduced, I think, last year in a new legislation on pay transparency that mentions intersectional discrimination, but before that it didn't exist. And why is that concept useful? Because it says it's not only the individual characteristics, it's not just, you know, age and gender, and then, you know, cumulatively, you know, this is multiple discrimination, so aggravated discrimination with some worse consequences for those using the algorithmic systems. But intersectional discrimination says that the way the different axes of disempowerment work, it's inextricable. You cannot separate the age from the gender, from the race. What happens is that you have this new situation of disempowerment called intersectional discrimination, and that the law should protect it. And it might be useful in algorithmic discrimination because it goes to the heart of structural institutional discrimination, where you do not have, separate, let's call it, characteristics that need protection. It is the whole of your experience and the complexity of your lived experience as it's influenced by structural institutions that you're discriminated on one basis of. So I think intersectionality could be a powerful tool and could be a way to overcome the limitations of non-discrimination law that says, okay, you only have discrimination if you could prove that you're discriminated on age. But with algorithms, they don't discriminate very often directly on protected characteristics. What they do is they draw correlations, they infer, and things are interrelated. Hence, again, intersectional discrimination. Sorry, it was very long answer.
Thank you very much. Now I'm going to ask a more technical and nerdy question. So suppose that you, Asja said, an organization that, for instance, licenses an AI system for recruitment should test and check whether it doesn't discriminate. So ideally, for instance, in the Netherlands, victims of discrimination are often from a Moroccan background, for instance. So ideally, to test whether your system discriminates, you would want to know 15% of the people that applied, that sent in letters for this job are Moroccan, and then you look who do we select in the end for a job interview. If that is 0%, that doesn't mean that therefore the system is discriminating. Perhaps they were less qualified, but nevertheless it's something to look at. However, in practice, we assume now an organization, a company that tries to do well and does well in compliance, etc. Because of the GDPR, you typically don't touch or even guess people's ethnicity. Similarly, with discrimination against on sexual preference, for instance. And I want to mention the GDPR. There are very good non-discrimination arguments for not allowing databases with gay people or people with a certain religion, etc. But without those data, it is hard, perhaps impossible, to check your AI system for discrimination. Very difficult topic. A colleague of mine, Marvin van Beckham, has written about that too, and you can make a pile of arguments, roughly 4 arguments, for keeping it like it is, like the GDPR says. Don't touch those data because the risks are too high, because databases with Muslims or databases with gay people are dangerous, can be used for horrible discrimination. Meanwhile, there's a pile of arguments for allowing the use of such data for debiasing AI systems. To me, both piles of arguments make sense, and then I tend to think, okay, let's be careful and conservative and don't allow it. The EU lawmaker now has said in the AI Act, it's complicated, but roughly summarized, for AI debiasing, under very strict safeguards, first try synthetic data, etc., it is allowed, or at least it is not prohibited anymore, a lawyer speaking, it is not prohibited anymore under certain conditions to use, for instance, data about people's ethnicity if you only use it to debias your AI systems or to detect discrimination and try to fight it. I was wondering whether panel members had any thoughts of that. So the lawmaker now made a choice, okay, we're going to allow it, but so we're stuck with that now. Perhaps it's a smart decision. I don't know, I'm agnostic. But we can also disagree with what the lawmaker did here. I was wondering if anybody had any thoughts about this. Perhaps from the same order? Or
I have thoughts, but maybe also like from a more general side. I think like all that research that goes into, how to fix things at a technical level is so important, and we're also part of the FINDHR project, and that's what we're doing there too. Like you know, trying to develop synthetic data sets and see whether that helps, and diversity enhancement and all of that.
Perhaps you could say what synthetic data are?
I think that's, I leave that to
yeah.
Asia, because she's like leading that part of the research actually. But just all like that research on the technical level is so important to fight bias and discrimination in these systems, but still we will not fix tech with tech, in the sense of we will not fix the implications that the use of these systems would have just by merely technical solutions, because also the roots of discrimination go beyond tech, right? They're rooted in society and in the way people use these systems and what expectations they have and the dozens of decisions they take before they deploy a system and so on. And I think that's very important, just like as a general remark first. And then, you know, that conflict, and as I said, I'll leave the more like technical response probably to other people also on the panel, but what I find really interesting about it is that, like, from a legal perspective, that's nothing new. That's, you know, you have two conflicting rights in a given situations. And has never been an easy question to solve that. And I don't think we will find a solution it's either okay or it's not, because that's, you know, how fundamental rights work. They have to be applied in concrete situation, and we have to weigh them, and we have to think of the arguments. And I think that's really a case-by-case thing then, actually, to evaluate.
Thank you very much. Roger, any thoughts?
Yes, thank you. I think we have quite similar experiences on that also from the bias project. So we are primarily using natural language processing to also see what is the language that is being used in both recruitment letters and CVs. And of course, what we all know is that AI can be really, really smart in recognizing patterns and seeing what does the data tell you about these large data sets. And even though you don't have like a mandatory field for writing nationality in your examples, we can still see that the nationality can be inferred through other data. So just to give an example, if you apply for a job in Norway, where I'm from, you often have this field called hobbies, where you would list what are your hobbies, what do you like to do outside of work, and almost everyone who applies write skiing, so they love to ski. Yeah, if you've been to Norway, you know that skiing is like the number one hobby. But then if you don't write skiing on your hobbies, you automatically mark yourself as not the majority in the bunch of applications, which can then be inferred with also other data. So for example, if you write which day of the week do you want to have off, maybe for religious reasons, or how big is your family, things like that can be used to combined say something about, for example, nationality or whereabouts you are from. So even though we don't have it explicitly, it can still be inferred by the system. But this is also about which culture you are applying for a job in. So in many countries, on CVs, you would put a picture on it to like show what you look like, and in I would probably guess most places you don't put the picture on it, but when you do, that can also tell you quite a lot about the person, which might be, I think in the US it's banned to have pictures, but some places in Europe you still have that.
Yeah, in the Netherlands we don't have rules on it, but many people spontaneously add a picture to their CV, indeed. Yeah. Asha, any thoughts? And perhaps you could give us a super brief layperson explanation of what synthetic data are.
Yes, okay, I can start with the synthetic data. So very briefly speaking, synthetic data is just data that is not collected in the wild from the users. So it's not real data describing any real person. It's not data that we collect as part of the operations of the platform from user behavior and so on. So it's not data that is collected in the real world, but it's data that we just generate from a computational model. Now, the way we create this model, this can be done in different ways. And typically, we think of synthetic data as being somewhere in a spectrum between completely random, perfect from a privacy perspective, but perhaps not very useful for any purposes that we might want to use it for. And on the other end of the spectrum, we might have data that perfectly resembles data that we would observe in the real world. So the data that has perfect utility would be useful for the purposes, say, of monitoring discrimination, but of course it doesn't offer any privacy protection because then of course it describes real people. So typically when we think of synthetic data, we want to generate sort of fake data that is somewhere there on the spectrum. Hopefully that's a good explanation for the purpose of this panel. Back to the question about the exemption. I think from a computational perspective, there are two ways to look at this exemption. One is that it's going to make things easier, and the other is that it's going to make things more difficult. So it's going to make things easier because, at least in the academic computer science community, most work in the area of algorithmic fairness assumes we have access to sensitive data and special categories of data. So if that assumption cannot be met in practice, that means most of the research that we're doing is not applicable in practice. So the exemption is perhaps going to make it easier for people to actually use most of the research that has been done so far. Now, I think it's also going to make things more difficult because I can see that this exemption is similar to any other principle or provision that we might have, say, in the data protection law. I mean, from a provision to practice, there is a long way. And so I think this exemption is just going to generate a huge body of work of people trying to interpret it computationally in terms of algorithms, in terms of data processing pipelines, in terms of technologies, in terms of ways to adopt this in practice within infrastructures of companies. So I guess we'll see. We'll have to make the best of it. Yeah.
Thank you. And there's now this subfield in computer science focusing on fair and non-discriminatory and more transparent AI, etc. And will they solve the discrimination problem because of the AI Act now allows them to touch this type of data? Or is it still, like Angela says, tech alone won't fix this?
As I mentioned before, most work in this space assumes we have access to that data, and the community is far from claiming that we have solved this problem. So I don't think, not in the near future.
Thank you. Then we'll have to struggle on. Yeah, Mila, any thoughts on this particular?
I find it interesting because the question of the debiasing and access to data is framed entirely within the data protection discourse. And it's less controversial in equality protection because this is something that equality practitioners have known for years. You need, we call it equality data. It is, the Fundamental Rights Agency has been including guidance how to collect sensitive data, such as race and ethnicity, non-binary identities, etc. You need this data to design positive action so that you can monitor equality and see which are the impacted disadvantaged communities so you can design measures. You need this data so that you report to international and European monitoring bodies. So it's not only what equality institutions have done is they've actually actively worked with their data protection authorities to make it possible to collect such data. For example, with recruitment, the French Defender of Rights worked with the CNIL, the data protection body, to develop guidance for recruiters. They actually developed a template, how to collect data on recruitment, precisely to do equality monitoring and prevention. In Ireland, the Irish Equality and Human Rights and Equality Commission, they've worked with data protection authorities to develop, again, guidelines so that they could monitor ethnic profiling, right, by the police. And they're trying to convince, so there seems to be, like I said, Fundamental Rights Agency has released explanation that it's not contravening data protection authorities, that there is a justifiable basis linked to enforcing, protecting equality law. The directives on equality bodies talk about disaggregated data, which is, you know, and so for us from the equality community, the problem is not, there is a problem with access, though our members, some of them have investigative powers, huh? But the bigger problem is that there is no such data. This is what we've been encountering. There is no disaggregated data. Good luck finding it. There, for example, Eurostat now has created a new task for inequality data to encourage disaggregation of data. But there is no regulation at European level that obliges member states to disaggregate data. This is all nationally. So it's an access, but also the availability of that. I think from an equality perspective, it is legitimate and justifiable to collect such data if the purpose of debiasing is to prevent discrimination. Yeah.
Indeed, it's good that you point out that this tension between data protection law and non-discrimination policy arises now in the context of AI and automated systems, but the discussion is decade old.
We don't see it as tension. It's just justifiable because of the legitimate interest of equality protection. I mean, there is a lawful basis there. It's, at least that's what some
I'm a bit.
But the fact
I'm a bit less optimistic about data protection possibilities there, but I don't want it to turn into we have a mixed audience, so I don't want to turn it into a too legal technical
what matters
discussion.
is that those public institutions work together. Data protection authorities work sometimes with equality authorities linked to sensitive data. That's the bottom line.
Would love to talk more later. We're gonna, if there's any questions from the audience, we're gonna take a few questions in a row and then give it back to the audience members. Even if you can talk loud enough, please wait for the microphone because this is also being recorded. And so yeah, please wait for the microphone. Whoa, so many questions. 5, we can do 5. Try to keep it brief. And yeah, start in the back and then here.
Yeah, thank you for the presentations. It was very interesting. We are working on the topic in 2 projects, and that's why I'm two questions. The first, we try to integrate the data subjects into discussing potential discrimination effects, and to integrate different or diverse people with with the focus on interactional backgrounds. Do you have something like this also in FINDHR maybe, or some ideas about integrating data subjects? And the other one is if you have also some ideas of how to address the Article 14 in the AI Act, which obliges providers to address discrimination, for instance, for monitoring AI systems. That's it. Thanks.
Thank you. I'm Gerrit Jan Twenne. I'm a lawyer doing a lot of data protection, class action lawsuits, and I'm also an academic professor at Leiden University and Open University. There seems to be a big bias, and perhaps with good reasons, against the machine. You all mention, well, humans have biases too, but still it might be better to have humans doing the interview or the selection than the machine, than the algorithm. I was wondering, is there any research done on humans doing better than the machine? Like a test group, and you see, okay, the humans chose not the Moroccan, but for some unknown reason, the middle-aged white guy. And what did the machine do? Is there any empirical evidence that humans are better? And I set aside the scale, because I guess if you look at large-scale projects, algorithms will probably do better because they do it in the time that we have assigned to that. And humans will take 3 years, and a machine can do it in a month or a day. Well, that is relevant in recruitment. We cannot wait with fulfilling the vacancy in 3 years. We need to do it in 2 months. So I think that is an aspect that is also not really discussed. But my basic question is there any empirical evidence that machines do worse than humans? Set aside the timing.
From Privacy International, thank you for this very insightful discussion. I have a question regarding the current context and the rise in large language models and AI models and those tools being new threats or just building on the existing ones, do you think that there is a political moment that we can make use of to try and tackle the issues that have existed in this system for a while now?
Hi, I hope that you have noted the question because a lot of them. My name is Florence. I work at Ferrero, the chocolate Italian company. We have a huge workforce, and the HR function is more and more interested in using those AI tools as a way to screen among candidates, because sometimes for one job position, 1,000 CVs arrives, including via LinkedIn and so on. Not using those tools would mean that a large majority of those CVs would be completely ignored, right? So better maybe to use the AI tools so that at least a fair chance is given to all candidates. But my question is more about the obligation of information, and in particular the fact that obviously those AI tools needs to be transparent, so that both the deployer, the person using it, and of course the service provider, if there is one, is able to explain to candidates the logics behind whether a person has been selected or not, for example. And my question in particular is, some service provider now come up with a solution where AI itself is explaining the logics. So there is a LLM generating the answer if a candidate asks for it. Like, why was my CV rejected? And then you have an AI solution scanning again the CV and knowing the attributes that were relevant for the algorithm will draft an answer for the person, the candidates. Do you think that this AI within AI for basically making the right to information a reality is smart or dangerous?
Thank you so much for the panel. My name is Aida Ponce del Castillo from the European Trade Union Institute. I would like to make a practical question for any of you. What happens, what would be your recommendation for candidates to know when they are exposed to AI systems? What can they do, or what is the way to go? Or when they have been rejected by AI systems, what can they do? What they have to go, knowing that labor laws really do not apply to them at that phase. So that's very important. Thank you.
Thank you for all the questions, and especially for the last one, because it was also on my list of questions. Yeah. So we're going to do the same order. Each panel member answers the question that you're most comfortable with. Don't feel that you have to answer, that each of you has to answer everything. We start again with Angela.
Yeah, tons of interesting questions. I'm just picking some that I think I have most to say about. So the first question was like about involving people affected, right? And I think that's just a crucial point, because, and that's often also not happening, be it in developing the systems, where it's actually also, you know, it's not just for justice reasons, but also because the systems will work better in the end if you, from the very beginning, take into the account the perspective of both those using the systems and also those being affected by the systems. And I think that's very important. Also, like, where does the data come from? As I just said, like, in the project, we're also like trying to experiment with these synthetic data sets that is based on actually a data donation campaign that we launched. So people send in anonymized CVs, and then they also have to, or can, they don't have to, but they can also answer like questions about sensitive data. So we again have the issue of data protection, and that was also like not easy to design the campaign. So in all these steps and processes, I think it's very important to include those affected, and then crucially also when you evaluate the systems, because you can't merely evaluate them from a technical side. You really have to, you know, work with people that are using it and are being affected by it. And I think these are like really crucial point also to make the systems better in the end. And should I just go on with the second question? And then, okay, because of course this huge question about human versus machine and what is actually better. I think my point is more that somehow I feel this comparison is mistaken because it's not only about the output. It's not only about the output, it's also about the process of, you know, when I'm vis-a-vis a judge, I think for me as a human being, it's very important to have that process based on rule of law and so on, to be in a position to argue for myself, to have someone listening to my arguments and, you know, reflecting on them and then take a decision. And I think that's one aspect that I found also very important in this recruiting debate. So it's also like the comparison human versus machine is like, we shouldn't just let the machine define the benchmark and everything that the machine can do is where we compare the humans, because it goes beyond this entire output. I mean, you also mentioned the scale is definitely also a, I mean, if we have a discriminatory algorithm, then just a lot of more people will be affected. And then also accountability, because if you know the recruiter took that decisions, you know, mostly you can, I mean, internally, for example, in a company, you can hold people accountable. You can do that if you're a public employer, then you even have more stronger tools for accountability. But also, you know, as a person rejected, it's not just hearing I was rejected and then I have some AI explaining to me why the AI rejected me, but maybe it helps me to just pick up my phone and call them and ask them and have a conversation. I mean, I'm aware that's probably not possible if you have 1,000 applications, but it's still different for me if I know there was a person and this person also have to justify their decision to me. So I think, you know, that's just my point of saying it's not only about whether the output is better, it's really also how did that output come about. But then, having said that, I think it's important to say, you know, there's of course also potential in these systems because they're really good at detecting patterns. So they could also be really good at detecting patterns of discrimination and injustices. But then we should also use them for that task. And probably not only for optimizing and efficiency gains and so on. So yeah. Question.
Roger?
Yes, I think the last question that was asked from the front here really shows that we are lagging a little bit behind on how to really govern this well. And I think also the amount of people who turned out up to this session shows that this is precisely the right time to be discussing this because there are many unanswered questions. I like the example from the Italian chocolate factory, if I heard it right. It really shows that when you have an organization that gets 1,000 applicants for just one position, of course it can be a full-time job just to go through and sort all these applicants. And one way that AI can really help in a very easy way, to take a banal example, is that if one of the requirements for the job is, do you like chocolate, yes or no? If you have someone answering no, could you eliminate like half of the applicants and at least get a little bit of help? I'm not an expert on chocolate, but yeah, just to to think a little bit about that. I wanted to answer the question from you heard the second question, because investigating how humans and machine differ a bit in the recruitment process is precisely what we're doing in the BIAS project. And we have had a lot of capacity building workshops where we're going through different cases where humans are making decisions, where machines are making decisions, and seeing how do they compare. What are humans good at, bad at? What are machines good at and bad at? And are there ways where we can enhance each other? And we're actually bringing one of our project installations to Amsterdam the 16th of July, so you can come by our box and try it out in person. And from the project, we do have quite an interdisciplinary team investigating this from several different sides. So from my side, I have several PhDs that I'm supervising who are doing this a bit more bottom-up, so they are going through interviews, field site observations to see how is this really felt by the people who are applying for jobs, then going through a job process, where does discrimination happen. We also have, from the legal side, we have research going on there from one of our colleagues, is actually in the room, Edward Fosch Villaronga. Could you just wave? One of your colleagues from Leiden, actually. So if you have legal questions, he is also very good at answering them. And then we are running a lot of these really intersectoral workshops with our Italian partner, with Maria Sanglilano. Yes, now I'm just doing some waving here. But I think we need to solve this not only from a technical side, but also really interdisciplinary through a lot of different, both academic and industry disciplines coming together. And I see someone pointing at the middle of the little sheet. So for those of you who joined a little late, we do have our bias sheet in the little tote bag that you all got, so you can also read more about it there.
Great. So also to mention some colleagues who are in the audience, when it comes to the first question about whether we are involving data subjects, Hera, who is here in the audience, is coordinating our participatory action research. So she's a great person to talk to. When it comes to the question of human decision-making versus machine decision-making and the usage in the algorithmic hiring pipelines, within the computer science literature so far, people have mostly focused on the algorithmic side. So how can we come up with technology that can even be used in that space? And now there is some ongoing work in the community looking at how those tools actually impact people's decision-making. So whether that changes how people make the selection. So the work on this within computer science community so far is scant, but it's ongoing. When it comes to generative AI and the usage of LLMs in the hiring pipelines, I think that I think there is a lot to be seen. One example that I believe you mentioned was the usage of LLMs to generate job descriptions, but I think they can be used in other critical places in the system, so generating performance reviews or generating CVs. I think what will be interesting to see is what sort of systemic effects the usage of these tools has on how people represent themselves, on how hiring decisions, interviewing decisions are being made. So I think that's something to observe in the coming months. I also really like the example of AI explaining AI decisions. One thing that comes to mind when I heard this question, this example, is what happens when an AI makes up an explanation that seems right, but it's not true. So nobody sees the problem, right? They got an answer that seems satisfactory, but maybe there is some discrimination going on in the background that no one ever is able to detect. I think this could be very problematic. And when it comes to that final question, what we should let people know about the algorithmic hiring tools and the pipelines, I think sharing knowledge about what the system does exactly, so transparency about the algorithmic process should be very helpful, because it impacts how people should present themselves, so how they should craft their job materials, their CVs, their recommendation letters. There is some knowledge that that might be obvious, for example, to professionals in the industry, that you should have certain keywords included in your CV that might not be available to job seekers. So the transparency about everything that plays a role in the process, I think is really important.
Mila, any thoughts?
If I may pick up on the last question, could you please clarify? You said that your question was what to do for what rejected job seekers could do in terms of seeking redress. Was it? So what do they do after they're rejected? Is there something they could do, basically? Well, this is right down my alley. So yeah, and they could always. They could send a complaint to a public equality authority. They could also go to the courts or administrative tribunal, but it's, yeah. No. But then it could be the equality authority that could help them obtain the evidence. If you go and you complain that you suspect that you've been rejected, and let's say that. You suspect that you're rejected for the reason, for example, that you are Moroccan, but the algorithm works on, for example, on postal codes or whatever. It is equality bodies could request information, so evidence for the employer on what basis or criteria the decision was taken. And if there is a reasonable suspicion that there was discrimination, then what equality law has, the burden of proof is reversed. So now it is the employer that has to provide evidence that they have not discriminated. And this applies to recruitment. It applies to job seekers, and under non-discrimination law, recruitment is quite broadly phrased. So it's not only the criteria upon which a candidate is evaluated, but it's also the context of the recruitment. If there are conditions that could prevent a candidate from meaning, for example, applying for a job. If an advertisement says Moroccans are not accepted, for example, so in other words, conditions are created to dissuade somebody, or if I have a certain, I'm autistic, and to be able to apply, there are certain accommodations that the employer needs to make, and they're not made, so I'm prevented from being recruited. This is already creates a presumption or is counted for accommodation for disability as a form of discrimination. So this solves partially the transparency challenge. And importantly, I think that with algorithmic recruitment, we should move to public and collective approaches of justice, because the individual approach puts too much burden, which is the case with any litigation, but specifically with algorithms, because of lack of transparency, unintelligibility, unpredictability, it's even worse. Equality institutions could be one solution, but also trade unions, civil society organizations, social partners. Under equality law, they could bring discrimination cases. Under the AI Act, sadly, they could not bring complaints to the market surveillance authorities. So there is no public interest organization bringing cases. But what the AI Act could allow us in terms of discriminated job seekers is it does include provisions of access to information for public fundamental rights authorities. Because, right, if a job seeker goes to a market surveillance authorities and says, well, I have a complaint, I think that I've been discriminated in recruitment. The market surveillance authorities, which could be data protection authorities, they have no expertise in non-discrimination equality. They're not trained to monitor discrimination and to enforce non-discrimination law. So there is really a disconnect between the two legal worlds. And under the AI Act, fundamental rights authorities have access to documentation and could request testing by the market surveillance authorities. So there is a way through which discriminated job seekers, they could, the equality body could examine the documentation and detect some patterns of discrimination. And then they could work with civil society, with trade unions. And finally, there's another hook that supervisory, so the market surveillance authority under the AI Act, they have to inform and fully cooperate, as appropriate, but with authorities protecting equality, fundamental rights. So even if the market surveillance authority has no idea what algorithmic discrimination in the labor market is, hopefully there would be some cross-pollination and exchange of expertise in that way. Yeah, I could say something else, but I won't.
Thank you very much. And we could have, no, I wish we would have a whole conference on this topic, but we don't. We only have one panel, and we're almost through our time. We have 6 minutes left, so I'll give you the chance for a final thought. That could be something that you completely think of yourself, or you could answer what you need from, for instance, you're an NGO and you're a regulator, what you would need from researchers or from other disciplines. But it's your own choice what you make your final thought. And then we do this order again. Angela?
Okay, just quickly reacting to that, I think that's a crucial point, like the redress point. That's, when it comes to improving protection from discrimination, collective redress, shifting burden of proofs, and so on. But yeah, I think like a general point that also came out a bit in the discussion that I think is really important also to your question, but yours to many questions actually, is that of course efforts in fighting discrimination by recruiting algorithms should not detract us that we also need to fight discrimination in recruiting in general. And I think that's a very crucial point. So that's not a separate field that needs to go hand in hand, because that's the recruiting space is one that is already characterized by discrimination, that is already characterized by power asymmetry, that is already characterized by the fact that people cannot really contest decisions, right? I mean, It's hard to do, as you said, especially on an individual level. And of course, that needs to go hand in hand, and I think that's a crucial part of it. So, you know, we need to fight, in a way, discrimination both by humans and by algorithms, and we cannot really say one is different from the other or needs different efforts. Yeah, and then what do we need as an NGO? I think what we always realize is that this is a topic that for many people is just so really abstract, and they cannot really imagine, you know, where are these systems used and how do they affect me? And still a lot of people are affected, of course, by the workplace. So what is important is to be really able to tell the stories, to have like the storytelling aspects. So how are real people affected by that? What does it mean for them? So this is something that we work with. We also do like investigative journalism, but that I think is just crucial, also the attention around the stories, to really show people this is something that is real and it affects real people.
Thank you very much. Roger, and everybody, please.
Tweet length, okay, yes. But I have a premium, so I can tweet for longer. No, just kidding. No, I don't. But I wanted to actually challenge some of your previous questions about when do we achieve fairness in recruitment, because I think we will never achieve fairness in recruitment, because it is always a bit on the horizon, because what is fair now, it can also change in the future, and we don't have to go many decades back to see several groups in society not being even valued as people or normal workers. So I think we must be very aware that we don't benchmark this time here and now as what we are aiming to solve in a way. And as social scientists, we can be a bit more chaotic than the technicians and the legal experts who want to solve a thing. But I think we need to be really open for new forms of discriminations, especially with intersectionality that was mentioned, that can arise also in the future for things we don't know yet, which maybe AI can help us solve. Yes, tweet and yes.
Asha, final thoughts?
Perhaps I'm not going to be very original, especially in this space, but I want to bring up the role of interdisciplinarity and sharing of expertise from different disciplines in solving this problem. It's something that we keep learning as part of our consortium, that when we don't have full awareness of what is important to other disciplines and how they are, from which angle they are looking at the problem of discrimination and algorithmic hiring, we can direct our efforts in just in the wrong place. And it happens over and over again in computer science, that we develop solutions under the assumption that we have access to certain data that we in practice cannot have, or we develop metrics and interventions that seem to work in practice technically, but it seems like it's not something that matters from a legal perspective when it comes to non-discrimination. So sharing of expertise and that interdisciplinary dialogue is key.
Thank you very much. I love calls for more interdisciplinary cooperation. Mila, any final thoughts?
I ditched the interdisciplinary PO. I'm part of the other, the exotic, the non-discrimination legal voice in the room. Final thought, technical standards and legal standards, connecting those. Equinet is now participating in the development of the technical standards under the AI Act, and there is a glaring disconnect. So if we inspect and audit assess technology based on technical standards, and if we assess the effects of technology legally, we have to connect the two. Yep. And what we would like from the technical community is to help us with that, and more specifically to help translate fairness metrics and fairness bias interventions, which is what you do with your research. What do they mean practically in terms of who gets disadvantaged or advantage? Who do we empower by making a certain choice of a fairness metric over another? Yeah. And legally is this permissible? Thank you.
Thank you so much. And I'm going to do something that usually I'm the most pessimistic one in every group. But I also wanted to point out research by the Dutch Non-Discrimination Authority, together with researchers from an Amsterdam university, on a large scale, so only made possible by AI. They checked tens of thousands of job ads to warn people like, hey, in such and such percentage, there is probably accidental. Nevertheless, there's gender-specific language in it, so steering already a kind of discrimination creeping in at that point, and that's a good example, I think, of what would be impossible for humans to read tens of thousands of job ads. So this is an example where AI can be used for good in a way that would be impossible by humans to do. So I'm trying not to and us thinking only of risks and threats. So thank you for joining, and thank you for all your inspiring questions, and thank you for the panel members.